Hello, I'm Daniel Chodos. I'm a partner with Witten and Lublin, and I'm here with my colleague Jason Jagpal. We're here to talk about temporary layoffs today. So the thing people need to know about temporary layoffs is that it's something that a lot of employers are generally allowed to do in certain circumstances. The general rules when it comes to temporary layoffs is that an employer is allowed to tell you and give you a record of employment that you're no longer going to be working for a temporary period of time that generally speaking has to be no more than 13 weeks in a 20-week period and no more than 35 weeks in a 52-week period. There's a series of rules about what has to be done, the most common of which is that your employer has to continue your benefits over this period of time. And one of the key issues that I'm always explaining to companies is in order to avoid lawsuits, and Jason's going to speak to this more than I will, you need to have a contractual clause with your employee allowing you to use temporary layoffs. Jason, what can you add to that?
Well, I'm glad that you raised that point about you need a contractual provision, because that's where a lot of the difficulty comes with respect to temporary layoffs. People will read the Employment Standards Act and they'll see that temporary layoffs are listed within the Employment Standards Act, and they will simply assume that the employer can therefore temporarily lay them off for 13 weeks within any 20-week period. However, that's not the case. What the truth of the matter is that an employer needs to reserve their right to temporarily lay off an individual within their employment contract. Or alternatively, if an employer hasn't done that, but they have previously temporarily laid off that employee, they've now reserved their right to temporarily lay off that employee in the future. This is a very important issue for particularly this season. We see a lot of summer layoffs, and with that, a lot of employees are not sure about exactly what their rights are. So, if you believe that you have been temporarily laid off, contrary to your contract, or contrary to what has happened within your employment to date, you may have an action for wrongful dismissal, because that same temporary layoff that is allowed under the Employment Standards Act would not be allowed in your situation because you do not have a contract provision allowing it, and it's never been condoned by the employer previously.